Chapter 9, Introduction to Contracts, presented by Kelly Hersick. Before we begin this lesson, I want to talk about the next 3 weeks. For the next 3 weeks, right up to the midterm, we're going to be discussing contracts in chapters 9 to 14. As far as topics go, contract law is the largest unit in this course. Contract law is incredibly important to business operations. Dunkin' Donuts has a great advertising slogan called, "The world runs on Dunkin'." My niece, who is a freshman at K-State, thinks the world runs on Starbucks instead. I do notice that the WSU Student Union has a Starbucks, but not a Dunkin'. However, it's a great slogan. The world does not really run on Dunkin', but it does run on contracts. Contracts dominate the business world, and in your personal life, you see contracts all the time. If you've ever bought a car, bought a house, signed a rental agreement, you entered into a contract. You probably have some intersection with contracts even when you don't think about it. For example, grocery stores list items, offer items for sale at a certain price. As a customer, you accept the store's offer to buy when you put the items in the cart and go pay for them. That involves an offer, acceptance by performance, and consideration, the 3 most important elements of a contract: offer, acceptance, consideration. When I was in law school, I had 6 credit hours of contract law over 2 semesters. So you can imagine the scope of the material that is available in contract law. We are going to cover this topic in only 3 weeks, meaning this will definitely be a survey of the most important issues and topics. Please pay attention to both the general rule and the exceptions, because I test on the general rule, but I also tend to test on the exceptions to the rule, because they're as important as the general rule, because that's where the traps are in the business world, where the exceptions are. Now, we're going to cover chapters 9 and 10 this week. Quizzes will be more like quiz 3, with less easy questions and more hard intermediate questions. I am trying to keep the curve at a certain level and am monitoring questions to see if students are having difficulty with a certain set of questions or a certain type of questions. However, if you listen to these lectures, you might get some clues on harder questions that will help you study. So, what is the lesson about this week in Chapter 9? We're going to start with the definition of a contract, since this is Introduction to Contracts. Then we'll talk about the sources of contract law, the classifications of contracts, the agreement, elements of the offer, termination of the offer, elements of acceptance, and mutuality of obligation. This is not the entire elements of all the contracts that we're going to be looking at. This is just the first block. Let's begin with definition of contract. A contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. That's a direct quote from the Restatement Second of Contracts, which we'll talk about a little bit later. But you can definitely tell that a lawyer wrote that definition. For students, an easier contract definition to understand is a set of legally enforceable promises. At its core, that's what a contract is, a set of legally enforceable promises. A contract has the following elements: agreement, which is generally offer and acceptance. We're going to discuss that here in Chapter 9. Mutuality of obligation, we'll also discuss that here with Chapter 9. Consideration, which is in the next block, Chapter 10. And then contractual capacity and competency in Chapter 11. Legality or legal object in Chapter 11. And a written instrument, which is sometimes required in Chapter 13. We will also talk about defenses in Chapter 12 and 13, and discharge and remedies from Chapter 14. What are the sources of contract law? There are two main sources of contract law in the United States. Common law, which is the case law. If you need a refresher, go back to Chapter 1 and review Slide 11. That'll give you a good summary of the common law. There is something called the Restatement Second of the Law of Contracts. This is not law, it is a treatise. It is a scholarly work. It's published by the American Law Institute. It is a compilation of general principles of contract law from the common law across the states. The restatement is not law because it's a scholarly work, but is often cited by judges in legal opinions who like scholarly works because it collects both majority rules in contract interpretation in the states as well as the minority rules followed by some states. Luckily for us, Kansas tends to be in the majority. Remember that businesses have to know state law where they're going to do business, as it does vary state by state. You have to look at federalism principles because you have the federal law, the state law, and local law that you have to comply with at all the same time. The other source of contract law in the United States is statutory law, the Uniform Commercial Code as adopted by the states. If you want a discussion on the background of the UCC, go back to Chapter 2, Slide 5. What you need to remember is that it was also a drafting project done by the American Law Institute in part, and aimed at standardizing interstate commerce across the states to the extent it could. We will discuss the UCC in more details in Chapter 15 and 16. Next, we're going to discuss classification of contracts, specifically bilateral versus unilateral contracts. This classification depends primarily on what the offeror, the party proposing the contract, expects from the offeree, the person agreeing to or accepting the contract. If the offeror wants a promise from the offeree to form a binding contract, the contract is a bilateral contract. This is a type of contract that is the most common, and it is the type of contract that is a promise exchanged for a promise. An example is if Betty offers to hire ABC Painting to paint her house for $5,000, and ABC Painting accepts and agrees to paint her house, that's a bilateral contract because there is a promise exchanged for another promise. On the other hand, there are unilateral contracts, and this is when the offerer wants performance to form the contract, and the contract is then called unilateral. This is a type of contract where the promise is exchanged for an act, which is performance. An example of this is Larry offers a $100 reward for the return of his lost dog. He posts it on a post and anyone and everyone can see it. Betty can accept this offer by finding Larry's dog and returning it to him. So the performance, the act of returning the dog safely, is the acceptance. That is, it doesn't require a promise, just the action. Now, in unilateral contracts, Larry can withdraw the offer at any time before performance. He can decide he's not going to give a reward and go pull down all of the signs. But once he knows Betty is performing, bringing him his dog, suppose Betty calls him and says, "Hey, I've got your dog, I'm on my way over." He can't rush around to try to withdraw that offer because Larry has to keep the offer open for a reasonable time for Betty to complete the performance. You can't take advantage and yank the rug out from under someone who is in the middle of performance in good faith. Next, we're going to discuss express versus implied contracts. This classification depends on how the contract is created. Express contracts are contracts with all the material terms expressly and clearly stated, either in writing for a written contract or verbally for an oral contract. We're going to use the same painting example that we did on the last slide. Betty and ABC Painting agree that ABC Painting will paint Betty's house by April 30th in exchange for $5,000. All the material terms are there. That's an express contract. Remember for testing purposes, though, that express contracts are often also bilateral contracts. You have to look at two different things when you're looking at those classifications. If you're looking at an express contract, All the material terms have to be there, but if you're looking at bilateral, it has to be a promise for a promise. We were able to use virtually the same example here, the painting example, for both an express contract and a bilateral contract, which should give you a pretty good clue about how bilateral and express contracts often overlap. Then there are implied contracts. These are called implied in fact contracts in some states. These are contracts that do not arise from words, but rather from the conduct of the parties. Parties never get around to sitting down and either discussing orally the contract or putting it in writing. Generally, there are three conditions that must be met for a court to find an implied contract. One, the plaintiff provided property or service to the defendant. Plaintiff expected to be paid for the property or service, and a reasonable defendant would expect to pay for the property or service. And three, the defendant had an opportunity to reject the property or service, but did not. They let the party provide the service or the property. The example here is a classic one. A doctor sets Betty's broken arm after a car wreck. They don't expressly agree about the cost or even discuss the cost of the doctor setting Betty's arm because it's an emergency. If Betty lets the doctor set the broken arm, and a reasonable person would expect to pay the doctor, an implied contract will be recognized to pay for the doctor's services, but at a reasonable rate for doctors in the area. The doctor can't say, well, my fee's $5,000, if a reasonable fee in the area would be $500. Next, we'll discuss quasi-contracts. Quasi-contracts are also known as implied in law contracts in some states. These are not actually contracts. Rather, these types of contracts are legal constructs created in equity law, in fairness, to prevent one party from being unjustly enriched at the expense of another. It's all about fairness and whether or not someone is taking advantage of another person unfairly. The courts will impose contractual obligations on a party to prevent injustice as if the party had actually entered into a contract, if they're acting unfairly. The key is that the enrichment must be unjust, must be unfair in the circumstances. The general rule is that courts will not require parties to pay for the mistakes of others. Quasi-contracts were created to ameliorate that general rule and to give parties who are treated unfairly or are taken advantage of an opportunity to be paid fairly. A good example is Larry lives next door to Betty and knows Betty is having her house painted. ABC Painting shows up and begins to paint his house instead of Betty's. Larry knows he did not hire anyone to paint his house, but he says nothing to the painting contractor, letting them paint his house. Only when ABC is finished does he tell them that they've made a mistake about the address. He tries to take advantage. ABC bills Larry for the fair value of the painting, $5,000, but Larry refuses to pay because he never entered into a contract with ABC. In a lawsuit brought by ABC against Larry, even though ABC and Larry never entered into a contract to paint the house, a court will likely impose an obligation to pay on Larry since he actively tried to take advantage of ABC's mistake. You cannot seek to get an advantage from someone when you know it's wrong and you know it's unfair. Would the result be different if Larry was at work and had no idea that ABC was painting his house until he got home and the painting was done? Well, probably yes, because then it's completely ABC's mistake and Larry didn't try to take advantage of it. Do you see the difference? Valid and unenforceable contracts. A valid contract is simple. It's a contract that includes all the legal elements of a contract and is usually enforceable. That's the general rule. A valid contract with all the legal elements is usually enforceable. Of course, with every general rule, there are exceptions, such that a valid contract becomes unenforceable. Contracts covered by the statute of frauds, which requires that contracts concerning the sale of land, the sale of goods for over $500, or contracts for a year or more, must be in writing to be enforceable. We talked a little bit about this in Chapter 20, so take a look at Slide 6 for a little refresher. Now, an oral contract for the sale of land, while it might be valid and have all the required elements of a contract, they simply are not enforceable under the statute of frauds. They must be in writing. What about the rental of land, a lease? Well, rental of land is not the same as selling land. That's a temporary issue. the rental of land, as long as the term is less than a year, they are enforceable even if they're oral contracts. And the reason being is that the third prong of the statute of frauds requires that only contracts that are a year or more have to be in writing. So a lease for 6 months, for 8 months can be an oral contract and it can be enforceable. That is the general rule of which you need to know. An otherwise valid contract may not be enforceable if a person waits too long to sue for breach of contract. There's something called a statute of limitation, and it's a statute requires that breach of contract lawsuits be brought within a certain set time period. In Kansas, you must bring your breach of contract claim within 5 years from the date of breach, or your contract action is barred. You may have a valid contract and a legitimate breach, but you can no longer sue on it because the statute of limitations renders that contract breach unenforceable. This makes sense because after 5 years, which is a fairly long period of time, evidence disappears, people's memories become fuzzy, it becomes exponentially more difficult for courts to render a just and fair decision. The next classification of contracts we're going to discuss are void and voidable contracts. This is probably one of the more difficult concepts in this unit. Law students have trouble with this. I have tried to take everything that you need to know for testing purposes and put it on this slide. Void contracts are not contracts. They have a goal that is illegal, or the contract has such a major defect that it's simply not enforceable. A classic example is a contract with an illegal purpose. That's a criminal enterprise, that's not a contract. A contract to kill your spouse for money is a void contract that is not enforceable. A contract entered into by someone who has been adjudicated in a court. There's a court order. If they are adjudicated mentally incompetent, those contracts are also void. They have no ability to enter into a contract, and if they do, it's void. On the other hand, voidable contracts are contracts where one or both of the parties has the ability to either enforce the contract or withdraw from it due to an error in its formation, such as capacity. That's the classic example. Minors and people who have not yet been adjudicated as mentally incompetent can withdraw from contracts because they are voidable. They lack contractual capacity. Contracts entered into under duress or undue influence or fraud are also voidable, meaning the person who's taken advantage of can get out of the contract or force the other party to stay in the contract, depending on their wishes. I call that should I stay or should I go. Typically, the party the court wants to protect is the one that can decide to remain in the contract or avoid it. Example, if there's been no adjudication of mental incompetency, a contract made by a mentally incapacitated individual is voidable by them. Minors can also avoid contracts they make. There are some states that have exceptions like necessities like for food or housing or clothing that minors enter into, but I'm not going to be testing on that, but I want you to be aware that that's not quite an absolute rule for minors. If the parties discover that the contract is voidable and one or both have partially performed and a party elects to avoid the contract and cancel it, the parties must return money or property and put each other in the same position as if they had never entered into the contract. A voidable contract basically disappears, and it's as if the contract had never existed at all, and so the courts want to put the parties back in the same position that they were in at the time the contract was entered into as much as humanly possible. Next, let's talk about two different classifications of contracts: executed versus executory, and formal versus informal. A contract is considered executed when all the terms of the contract have been fully performed. As long as some of the duties under the contract have not been performed, the contract is considered executory. Let's go back to our painting example. When Betty hires ABC Painting to paint her house and she makes a down payment of $1,000 prior to the work starting, the contract is executory. It stays executory until the house painting is complete and Betty pays the remaining balance due. At that point, it becomes an executed contract. A formal contract is one that has a special form or must be created in a specific manner. These are old common law forms. By and large, modern contract law, they don't exist all that much anymore, except for negotiable instruments. But contracts under seal, that's literally where they used to stamp the wax. Those hardly ever appear anymore. I've never seen one in 30 years of practice. Recognizance do exist some. There are open promises in open court. Again, pretty rare. There are letters of credit. Letters of credit do still exist. And then, of course, negotiable instruments. They are probably the most common in current contract law, and that's under the UCC, and we'll talk about those in Chapter 17. Informal contracts are every other type of contract. They can be very complex, they can be 100 pages, but they're still considered informal because they require no formalities to make them unlike formal contract types. We're going to turn from the classification of contracts to what the authors of your book call the agreement. To the authors of your textbook, the agreement consists of the first two traditional elements of a contract, offer and acceptance, plus mutuality. In the book, I think for convenience of presentation, they have consolidated really the first three traditional elements of a contract, offer, acceptance, and mutuality, really into something that they call the agreement. Under the common law, the agreement begins when an offeror makes an offer to another party, who we call the offeree. There are three elements to an offer: intent, definite and certain terms, and communication to the offeree. They're very simple, but they can cause a lot of problems if you don't pay attention to the three elements. Let's talk about intent. The offeror must show an intent to be bound by the offeree's acceptance of an offer made. You can't basically make a joke. It has to be an actual serious offer. Courts determine intent based on the party's outward reasonable intent rather than any subjective or hidden intent of the parties. Modern contract law looks at reasonableness, not what the individual person might or might not have thought about their intent. Preliminary negotiations, which is an invitation to negotiate or an expression of interest, is not an offer. It's not definite enough. There's no intent for there to be an acceptance. Advertisements are not usually considered offers either. There's some exceptions, but you just need to know the general rule here that advertisements are not usually considered offers. Auctions with a reserve, which is a hidden minimum that the auctioneer knows, are seen by courts as merely the seller's willingness to receive offers from bidders, okay? But if there's no reserve, if the billing is the item is going to be sold to the highest bidder, period, then the seller is presumed to be making an offer to sell to the highest bidder, and that's an actual offer. If intent is the first element of an offer, the second is that the terms of an offer must be definite and certain, meaning that all the material terms must be included in the offer. Material terms are those that allow a court to determine what the damages are in the event of a breach of contract. If the contract is so vague the court doesn't know what to award, it's unenforceable. Sometimes the offer does not contain a material term, but that isn't always fatal. If the offer contains a method for calculating the term, then it's okay. For example, in mortgages, often there are what they call variable rates. This means that the interest rate isn't fixed over the entire time of the mortgage, but it varies year to year. Many times in notes and mortgages, you will see an initial rate of 4% or some other percent, and then a method to calculate the variable rate each year after the initial rate expires. That's fine because the courts can go in and sufficiently determine what the term means and how they could calculate damages in the event of a breach. Usually the court fights are whether the terms are sufficiently definite or are too vague to be enforced. The need to state the terms of an offer clearly and concisely cannot be understated. If you don't think about the scope of your offer and what you're actually offering and how it's going to be accepted, litigation will inevitably ensue. The third element is that the offer must be communicated to the offeree or the offeree's agent, and only the offeree to whom the offer is directed can accept it. If it's a specific offer that requires an exchange of promises, a bilateral contract, it can only go to the intended offeree. I can't see someone else's email and go, hey, I'd like to accept that offer, and go in and substitute myself and create a binding contract, because I am not the person to whom the offer was made. Now that we've discussed the three elements of an offer, let's discuss termination of the offer. When an offer terminates, it can no longer be accepted to form a binding contract. There are 5 ways to terminate an offer: revocation by the offeror, rejection by the offeree, death or incapacity by the offeror, destruction or subsequent illegality of the subject matter, and lapse of time. There is one other, it's called failure of another condition specified in the offer, but that happens pretty rarely. Offers usually expire most often through lapse of time, meaning that if not accepted by April 30th, the offer expires. Revocation by the offeror. The offeror is the master of his offer and can revoke or withdraw it generally at any time. He can even do that if he says he will hold the offer open for a certain period of time, and the revocation is effective when the offeree receives it. Now, of course, that's the general rule. There are a couple of important exceptions. The first is an option contract. In an option contract, an offeree gives consideration, usually money, to the offeror to hold the contract open for a set period of time. It happens a lot in real estate contracts. You have an option to buy after you're leasing. That's sometimes an option contract where you pay money for having the ability to buy the property at a certain given time. Another is a unilateral contract where performance has begun. We've discussed that earlier when we were talking about unilateral contracts and Larry and his lost dog. Another way that an offer can terminate is rejection by the offeree. If the offeree rejects the offer terminates outright. Counteroffers are a little bit more complicated. A counteroffer to the original offer is a rejection of the first offer, terminating it. So what does that mean? I think that's best illustrated by an example. Larry offers to buy Bob's car for $5,000. Bob rejects that offer, but counteroffers to Larry to sell the car for $10,000. Bob's counteroffer terminates Larry's original offer to buy the car for $5,000. So if Larry rejects Bob's offer to sell the car for $10,000 and walks away, Bob cannot later come back to Larry and say, I changed my mind, I accept your offer to buy the car for $5,000. In that instance, Larry is under no obligation to buy the car for $5,000 and no contract forms because the offer terminated. It disappeared. There was nothing left for Bob to accept because his counteroffer terminated Larry's original offer. Death or incapacity of the offeror. This is fairly straightforward. If the offeror dies or loses contract capacity while the offer is outstanding, the offer is terminated. It's gone. An offeree cannot enter into a contract with a person that lacks legal capacity or the dead. There is a major exception. It's called the option contract that we just talked about. An option contract would bind the estate of the deceased or the guardian of the incapacitated, meaning the estate or guardian would have to leave the offer open per the terms of the option contract until it expires. Destruction or subsequent illegality. If the object of the offer is destroyed, the offer terminates. Or if the subject matter becomes illegal, the offer terminates. For example, if someone is offering their vacation home for sale and it's destroyed by a hurricane, the offer for sale is terminated. The property's gone. There's nothing to sell. With respect to subsequent illegality, a good example is this. A bartender job offer to serve liquor at a bar would terminate if the bar does not get its liquor license, making it illegal to serve alcohol. That means that the subject matter of the offer to serve liquor disappears because it becomes illegal for the bar to do so. The last way an offer can terminate is lapse of time. If the offer states that it is open for only a certain time, once that passes, the offer terminates. But if there is no time expressed in the offer, then the court will impose a requirement of a reasonable time that the offer must remain open before it terminates. Now that we've finished discussing offer, which is the first element of a contract, we'll move on to the second element, acceptance. Once a valid offer has been made, an offeree has the power to accept that offer and form a contract. Under the common law, there are 3 requirements for a valid acceptance, and they pretty much mirror the 3 requirements for an offer. 1, the manifestation to be bound by acceptance to the contract, agreement to the definite and certain terms of the offer, and 3, communication of the acceptance to the offeror. Manifestation of the intent to be bound by acceptance. Acceptance can either be by return promise or by performance, depending on the requirements of the offer. Example, we talked about that in bilateral versus unilateral contracts. It's important to note that silence is generally not a form of acceptance. There are some limited and narrow exceptions, and here are the 3 elements. 1, the offeree receives the benefit from the offer with a reasonable opportunity to reject them, but does not. The offeror states that silence can be acceptance, and the offeree intends by his silence to accept. That's very important. And 3, by course of conduct of the parties, acceptance can be implied. That's silence. It's very narrow. Courts usually do not allow a party to impose a contract on a person who doesn't respond. Silence is usually not a form of acceptance. There's that very narrow exception that I just read, and that's it. The second element of acceptance is acceptance of definite and certain terms. This is known as the mirror image rule. An offeree must accept the offer as presented, including all its terms, meaning he cannot pick and choose certain parts of the offer to accept. This is called the mirror image rule. The acceptance must mirror the exact terms of the offer to form a contract. Under the common law, if acceptance does not mirror the offer on all terms, it serves as a rejection of the original offer and is treated as a counteroffer, which the original offeror can then choose to accept or reject. That was illustrated in the car example with Larry and Bob and the offer to buy the car for $5,000. Because Bob did not accept the $5,000, which was a material term, but instead offered $10,000, that terminated Larry's original offer to buy the car, leaving Larry free to either accept or reject Bob's counteroffer to sell the car for $10,000. The last element is communication to the offeror. An offeror can control the method by which offers can be accepted, meaning an offeror can determine how acceptance of an offer is communicated to him or her. For example, a statement that acceptance can only be in writing via certified mail would mean acceptance via a phone call would not be effective. If no method of acceptance is specified, communication can be by any method reasonable under the circumstances. Courts have found that telephone, fax, telegram, mail, and even email have all been determined to be valid means of acceptance under various circumstances. Now let's talk about an old doctrine of acceptance that still has relevance today. It's called the mailbox rule. This common law rule was originally created to determine when an acceptance of an offer by mail became effective, such that an offer could not be withdrawn. This was way before the internet, before email, so that's how come it's called the mailbox rule. Under the mailbox rule, an acceptance becomes effective when placed in the mailbox, while a revocation of an offer is only effective when received by the offeree. Because remember, rejection has to be communicated to the offeree. In modern courts, faxes and emails are also governed by the mailbox rule, meaning they are effective acceptance once they're transmitted. If you are doing an acceptance of an offer via email and you hit send, that's effective acceptance. But what about the effect of an acceptance that happens after a rejection? Let's start with the easy scenario. If an acceptance is attempted after a rejection is received, the exception isn't valid because the rejection terminated the offer. You can't accept something that doesn't exist anymore. But what about the other situation where the letters cross in the mail? Sometimes an acceptance is transmitted before a rejection is received by the offeree. Now, this creates a valid contract because the rejection is not effective until actually received by the offeree. Remember, the offeror is the master of their offer and they have to communicate the termination of an offer to an offeree. If the offeree does not know that the offer is terminated, they're free to accept it. And if they accept it before they know about the termination, then there's a valid contract. It's all a matter of timing. Here's an example. Larry is offered to sell his car to Betty for $5,000. He hasn't specified a method of acceptance, and Betty emails him to accept the offer to buy the car for $5,000. However, unbeknownst to Betty, Larry mailed a rejection of the offer to Betty, but Betty has not received it. When she emailed Larry, she didn't have the letter in her hand, so she did not know that the offer had been terminated, that the offer had been withdrawn. So it was still out there free for her to accept. If she accepts the offer by email before she gets the letter of rejection or termination, Larry will be bound by the contract to sell the car. We've now discussed offer and acceptance, the first two elements of a contract. The third traditional element of a contract is called mutuality of obligation. In more modern contract law, this element is described as mutual assent, as expressed by a valid offer and acceptance. Mutuality has kind of become part of offer and acceptance, but I listed it as a traditional element because you will still see it in lists of contract elements even today. Mutuality of contract refers to the reciprocal understanding or agreement of the parties, which is an essential element in the creation of an enforceable contract. The parties have to agree and know that they're entering into a contract. They have to agree on all the material terms. An important idea in contract law is that both parties should be bound or neither should be. There are exceptions, of course, to that general rule, and they would be the unilateral contract or a contract induced by fraud where only the fraudster would be deemed to be bound under the law. Another good example of a contract that is still enforceable that might lack mutuality of obligation are insurance contracts, which are primarily considered unilateral, and the terms generally only bind the insurance companies. What happens if a contract lacks mutuality? Lack of mutuality means a lack of understanding or a lack of a meeting of the minds. Meeting of the minds is just really mutual assent in modern contract law. It's a legal construct that requires the parties entering into a contract to discuss the material terms and duties of a contract and then agree to those terms and duties. It's offer and acceptance. If the parties do not have the same basic understanding of the contract, courts say that the parties have no meeting of the minds and that invalidates the contract. It describes the intent of the parties and their common understanding in the formation of the contract. Under modern contract law, mutual assent is based on objective manifestation of assent rather than subjective assent. Go back to slide 11 where we first talk about mutual assent. It's a reasonable person standard. This simply means that the courts will look at all the facts and circumstances to determine if a reasonable person in similar circumstances would believe a contract had been formed. This is the end of Chapter 9.